Hello, in this video we will discuss about the proposal and its essential elements to create a valid contract. Okay, and we will also discuss some of the leading cases relating to the proposal. So the word proposal has been defined under section 2 of the Indian Contract Act 1872, which says that when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtain the assent of that other to such act or abstinence, he is said to make a proposal. Okay, so now we will discuss about the difference between an offer and an invitation to an offer. An invitation to an offer is just when a person does not make an offer but invites other person to make an offer. Its best example could be the auction selling. In auction, the person who is selling does not make an offer, but he invites you to make the bid, and if you make the highest bid, then he can accept the bid. He is not obliged to accept that bid because you have made an offer, and he can or he may or may not accept that offer. So this is the best example of invitation to an offer. Other example include catalog by bookseller. Okay, so let's discuss the case of Harvey versus Facey, which is important case for studying this concept of invitation to an offer. So in this case, quotation of price was not held to be an offer. In this case, the defendants were owner of a property named Bumper Hall Pen. So the plaintiffs were interested in this property, so they sent a telegraph to the defendants asking what is the are they willing to sell are the defendants willing to sell the Bumper Hall Pen and telegraph its lowest price. So the defendants telegraphed the lowest price being 900 pounds. Now the plaintiff again telegraphed that he is willing to buy that property for 900 pounds, but after that the defendants denied to sell the property. So in this case, the information, the price which was provided by the defendants as the cost of the Bumper Hall Pen was only an invitation to an offer and was not an offer to sell the property. Two questions were asked, one regarding the willingness of the defendant to sell the property, and the other was the lowest price. Only the second question was answered, so he could not buy the property. In this case, related cases of Macpherson versus Aparna, which is also related to the invitation. So now we will discuss about some essentials to a proposal to create a valid contract. So there are some essentials, like there must be intention to create legal relationships. There are many agreements which does not result in the contract. Like if you ask someone to take him for tea, and if you ask someone to take him for theater, okay, so all these agreements are all social agreements and they does not result in contract because there is no any intention to create legal relationship. So there must be an intention to create legal relationship when you are acting. While the case of Balfour versus Walford depicts this situation. In this case, the defendants who lived in Ceylon went to England to enjoy holidays with his wife. The wife, due to health reason, was advised to stay in England. So the husband promised to pay wife a sum of £30 per month, but after some time he stopped paying the money. So it was held by Lord Atkin that there was no any intention to create legal relationship, and hence no contract exists between them. In yet another case of Jones versus Padwetton, in this case the defendant lived in Trinidad and her divorced daughter and her young son lived in Washington, and her daughter worked at Indian Embassy in Washington. On mother's insistence, daughter left the job and came to England for higher studies, and her mother promised to pay for her studies. But some difference arose between the mother and daughter, and the mother stopped paying the money. Now the daughter sued the mother for her money, but it was held that there was no any intention to create legal relationship, and the plaintiff's claim failed. That is, the daughter's claim failed. But it could not be said that all the social agreements does not result in a contract. There are some social agreements which can result in a contract. If there is a legal relationship, if there is some intention to create legal relationship, then within family, agreement within family could result in a contract. A case depicting this situation is the case of Merit versus Merit. In this case, husband and wife were the joint owners of a building which was subject. In the case of Merit versus Merit, in this case, the husband and wife were the joint owners of a property which was subject to mortgage. So on the insistence of the wife, husband transferred his share in the property to the wife with a condition that the wife will pay all the remaining amount which is due. Okay, she will pay all the loan because the husband has transferred his share in the property to the wife. So it was held this was held to be a valid contract, although it was a social agreement between a husband and wife. So it was held to be a valid contract. It could not be said that all the social agreements does not result in a contract. If there is any intention to create legal relationship, then the social agreements can also result in a contract. So the next condition is that communication of offer necessary. Section 4 of the Indian Contract Act says that communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. Yes, it's a common thing that if you do not know the offer, then how you can accept that offer. A case depicting the situation is the Lalman Shukla versus Gauri Datta. In this case, defendant's nephew went missing from home. The plaintiff, who was a servant of the defendant, was sent to search for the missing nephew. After the plaintiff had left, the defendant announced some reward on to the person who will find the nephew. Okay, and when the servant has found uh, the nephew, and when he came to know about the reward after finding the nephew, then he just claimed the amount, he just claimed the reward which he never knew of. He only came to know of the offer when he has just found the nephew. So it was held that there was no any communication of proposal, and hence he acted in ignorance of offer, and the said offer was never communicated to him and was never accepted, as he got to know about the offer only after finding out the nephew. The related case in this regard is the case of Williams versus Karl. We'll discuss about some kinds of offers. Okay, so the first one is the cross offer. When the offers made by two persons containing the same terms of bargain cross each other in a post, it is said to be known as cross offer. For example, B has offered to sell his bike to A for rupees 50,000, and A has also offered to buy the bike of B for rupees 50,000. This is considered to be a cross offer, and in this case no any contract arises because there are only offers on from the two parts, and there is no any acceptance of the offer. So related case in this regard is the case of Tin versus Hoffman. No contract arises in cross offers because there are only the offers from the two sides. There is no any acceptance of the offer. Now we will discuss about the specific and general offer. When offer is made to a specific person, it is called a specific offer, but when offer is made to a public at large, it is called general offer. Anyone could accept general offer who performs the condition of offer. That is, for an example, an offer to give reward to anyone who finds the dog is a general offer. So anyone who can perform the condition, anyone who finds the dog can accept the offer. Okay, so the case, one of the important case in this regard is the case of Karl versus Carbolic Smoke Ball Company Limited. This is the case of 1893. So in this case, defendant gave an advertisement in a newspaper that whoever uses the medicine Carbolic Smoke Ball regularly as per the instruction, he will not contact with the influenza. But the plaintiff used the medicine as per the advice and as per the instructions given in that advertisements, and she contracted influenza. So plaintiff brought an action against the Karl Smoke Ball Company Limited. So it was held that it was a general offer and could be accepted by anyone fulfilling the condition. Acceptance in these offers are not necessary. Acceptance in general offers are not necessary. They could be accepted by just performing the conditions. We'll discuss standing open or continuing offer. These all terms are synonymous. So when an offer is allowed to be accepted for a particular period of time, it is called open, standing or continuing offer. For example, an offer to supply 1,000 bags of wheat from 15 January to 15th August on the basis of order which may be placed from time to time is an open or standing offer. This offer could be accepted at any time like any ordinary offer. Okay, it could be revoked at any time like the ordinary offers. Okay, so standing offer could be understood from the case of Bengal Coal Company versus Homi Baji and Company. The defendants Bengal Coal Company agreed to supply coal to the plaintiff up to a certain quantity at a fixed price up to 12 months as may be ordered from time to time. Orders were placed by the plaintiff and the same were complied with. Before the expiration of 12 months, defendant revoked the offer. It was held that it is an open offer and could be revoked at any time. So the offer has to be placed from time to time. Okay, there is a specific time of 1 year or 6 months, you have to place offer within that. And that offer has to, if that offer is accepted, then that offer has to be performed. Okay. Okay, for example, like